Welcome to the Judicial Committee of the Privy Council, where today we're beginning the hearing of two appeals from the Court of Appeal of the Eastern Caribbean Supreme Court. I'm hearing these appeals with 6 other members of the board, whom I'll introduce now. First, Lord Hodge.
Good morning.
Lord Briggs.
Good morning.
Lord Sales.
Good morning.
Lord Hamblin.
Good morning.
Lord Leggett.
Good morning.
And Sir Geoffrey Voss.
Good morning.
Details of the two appeals can be found on the Privy Council website, but in brief, the first appeal in the case of Convoy Collateral and Broad Idea International concerns freezing orders, that's to say provisional orders made by a court restraining a party from disposing of or dealing with his assets. And the main issue is whether the courts of the British Virgin Islands can grant such an order against a person where there is no cause of action against that person, and whether such an order can be granted in support of proceedings to which that person isn't a party. The other appeal in the case of Convoy Collateral and Cho also concerns a freezing order, and the question is whether the BVI courts can grant such an order in support of foreign proceedings, and in addition, whether they can grant permission to an applicant to serve an application for such an order out of the jurisdiction under the civil procedure rules that apply in the British Virgin Islands. We'll be hearing submissions first on behalf of Convoy Collateral, who are the appellant. They're represented by Mr. Paul McGrath, Queen's Counsel. So I'll invite Mr. McGrath now to begin his submission.
Good morning, my lords. As my Lord Reid has indicated, the two principal issues that arise in these combined appeals from the Eastern Caribbean Court of Appeal relate to two issues that we've identified in our statement of case. The first, called the power issue, whether the Court of Appeal was correct to overturn the Black Swan line of authorities on the basis of the reasoning in the Susquehanna and Mercedes-Benz, with the consequence that it's not possible to obtain what we've described as a standalone freezing order in the BVI. And the second principal issue, which we've described as the territorial jurisdiction issue in our statement of case, is that even if such a power existed, whether the Court of Appeal was correct to say that such an injunction did not fall within an injunction gateway for the purposes of serving out of the jurisdiction. There is a third, more discrete point, which relates to Chabra, which I'll deal with towards the end. My lords, we bring this appeal recognising the very heavy burden that rests on us in terms of what we need to persuade your lordships of, and therefore it will be no surprise that my lord's submissions really will focus on why we challenge the reasoning in the Susquehanna and Mercedes-Benz in the context of this case. I will also need, towards the end of my submissions, to address your lordships on the recent development, which is not contained in my statement of case, the new legislation in the BVI and the extent to which, if at all, it impacts on any arguments today. Well, can I begin, before we get too heavily into examining the relevant cases and our arguments, can I begin with some preliminary observations? It struck me that when confronted with submissions seeking to challenge two such cases of the Susquehanna and the Mercedes-Benz having taken a wrong turn, the first question that your lordships might have in mind, obviously, is the basis upon which we say they took a wrong turn. And obviously, I'll need to address you, although I've done that to a certain extent in the statement of case. But perhaps of equal importance is, how did the courts come to make such a mistake if we're correct in how we characterize events, because it can rightly be said, and it's said against me, that these decisions have been in existence for some time, and they therefore overturning them or challenging them might have an impact in relation to many cases that have flowed and followed their reasoning. And so I think it's important that we put it in its context. When I do that, hopefully, my lords, it's a useful exercise. It's a short one, but it will then reveal the wrong turn and how that came about. So just looking very briefly, if I may, before we get into the cases, firstly as to how did we get here. The reality is that the recognition of the freeze and order jurisdiction from the outset faced substantial legal obstacles as a matter of English law. But it appears that in the mid-1970s, the perceived need and desire for the freezing order injunction jurisdiction, or the Morava as it became known then, has prevailed over any attempt at the time to seriously confront those obstacles. And I'll make good those points in a moment. And when it came to the Susquehanna, there was an avoidance of any detailed scrutiny of the nature and rationale of the freezing order jurisdiction. It simply wasn't engaged for the reasons that I'll address your lordships on and show from the judgment. And so the result was that Susquehanna ended up applying criteria to the freezing order jurisdiction, which may be relevant to the ordinary interlocutory injunction, but it is fundamentally inconsistent with the role of the freezing order jurisdiction as a whole. Now, no doubt much of the sting of this was taken out and pulled by virtue of Section 25 of the Civil Jurisdiction Judgments Act being enacted in English law. And during that period of time, the freezing order continued to bed itself in and become extremely well established and welcomed armory of the litigator fighting international fraud. When the matter came to Mercedes-Benz, it's quite clear that the majority recognised the need for such a detailed analysis of the rationale of the freezing order jurisdiction. Lord Mustell, speaking for the majority, discounted the only rationales that had been put forward by that point, namely those put forward by Lord Denning in the early cases, and also importantly noted that they were, one of the grounds for discounting them was that they were inconsistent with the reasoning in the Susquehanna. Unfortunately, he then said that he wasn't able to take the matter any further. Only Lord Nichols undertook a serious analysis in Mercedes-Benz of the nature and role of the freezing order. And these submissions today and these appeals build on and rely heavily on his analysis. So, Lord, then can I turn to an overview, again, just before I trouble the court with some cases, of the framework of what we say and propose in respect to the freezing order. We say that the BVI court has power to grant a freezing order to protect the integrity of its enforcement regime if, one, a set of substantive proceedings, whether domestic or foreign in nature, have been or may soon be commenced against the defendant. Two, any resulting judgment from those proceedings would in principle be capable of being enforced in the BVI, whether as a domestic judgment or as a foreign judgment according to BVI's ordinary conflict of laws rules. Three, there's reason to suppose that the BVI enforcement process may be called into action in respect of this putative judgment. And that would be, for example, the presence of assets in the BVI against which enforcement may be required, or the incorporation of a company in the BVI, or both. Four, that the BVI typically makes the freezing order jurisdiction available to protect its own enforcement process if required. So we're not asking it to do something that it would not normally do. It's seeking to protect it. If it would normally grant the freezing order jurisdiction to protect its enforcement process, then that requirement would be established. Five, the criteria for the freezing order injunction is engaged on the evidence. And it's quite important to appreciate that when we talk about granting a freezing order judgment injunction, one's dealing with a self-contained, carefully crafted regime which is tightly controlled and regulated by the courts, should not be lightly sought, certainly is not lightly granted, is the subject of detailed scrutiny by the court, additional duties to protect the position of the respondents, and the standard form whose terms and requirements are constantly under review as and when the freezing order meets new occasions. So one inserts into this scenario a self-contained regime in which interests are protected. And we say that's an important point to appreciate, because it's said against me that my arguments might lead to procedural unfairness in the absence of a trial, etc. And we say nothing of the sort would happen. If the defendant to the freezing order is subject to the personal jurisdiction of the BVI, it's point 6, then the BVI is best positioned to control that defendant's conduct. And that is the black swan jurisdiction endorsed, we say, by the BVI Court of Appeal in UKOS. 7, if the defendant, however, is overseas, we say that the freezing order falls within the terms of the injunction gateway. And the BVI's involvement will be limited to that permitted by the injunction gateway, which is controlling conduct, which ultimately will have an impact on its enforcement process. We say the BVI is the most appropriate jurisdiction in those circumstances to restrain that conduct, because it is conduct that, if allowed to continue, potentially interferes wrongfully with the BVI's own enforcement regime. As regards the position of the defendant or respondent to such an order, that person will have done something which has rendered the enforcement process in the BVI likely to be invoked. So, as I said earlier, chosen to incorporate a company within the BVI or locate assets here. And just pausing at that point, because it comes up again in Mercedes-Benz from Lord Mustel. It's not part of our case that the location of assets gives a grounding for jurisdiction over an underlying substantive cause of action. We're talking only about an injunction, and an injunction which therefore would be focused on those assets or that company. It is not the old argument that the existence of an asset brings with it all manner of personal claims against the defendant. We don't argue that. And as we'll see in the Susquehanna at all levels, that the confusion between those type of arguments was at play. But we are looking here for an ability to serve a freezing order out of the jurisdiction relating only to the freezing order. And if I might borrow some reasoning from Lord Mustel in Channel Tunnel, as he said, that the standalone interim relief sought there is not seeking to assert jurisdiction over the underlying substantive cause of action, but is limited to the interim relief. And that is what we are saying here. And we say that it would be illogical for the BVI's ability to prevent interference with its own enforcement process to depend upon the fortuity of whether the defendant happens to be within or without the BVI jurisdiction. Because as a matter of policy, one might ask why the BVI citizens within the BVI and subject to personal jurisdiction of the court would be held to a different standard than a foreign investor who decides to make use of the BVI to hold his or its assets. The negative impact on the BVI's offshore reputation as a financial centre is plain if one does not allow such relief, should it exist, to be served out. Now, importantly, the power to grant the freezing order in these scenarios is engaged not by reference to the nature of the underlying substantive legal rights in dispute in the claim. It is not by that nature that the power is exercised, nor is it relevant to whether the BVI has jurisdiction over the underlying dispute relating to those legal or equitable rights, or whether the putative judgment, which is the subject matter of possible enforcement, derives from domestic or foreign proceedings, because both judgments of both types would be enforceable in principle in the BVI. Nor, we say, does it matter whether the judgment debtor, the putative judgment debtor himself or itself, is within or out with the BVI. The power is exercised by reference to the potential enforceability within the BVI of the putative judgment and the satisfaction of the self-contained freezing order criteria. When asked, well, why should the BVI become involved in circumstances where it is not dealing with the underlying cause of action? The first and perhaps most important reason is the same reason it becomes involved when it is involved in the underlying cause of action. The reason is the same. It is the protection of an enforcement process. And as I'll come on in a moment to mention, the use of language like standalone just adds somewhat to the confusion that we're doing something different here than would happen if the underlying cause of action happened to take place in the same jurisdiction. And we'll see that in the Susquehanna at all levels, from Mr. Justice Carr, Lord Justice Bridge in the Court of Appeal, and up to Lord Diplock, they all began by recognising that to that point, the freezing order had only ever been granted in circumstances where the underlying cause of action was already before the English court. Well, as a historical fact, that's correct. But that, we say, only obscures proper analysis of what the freezing order is doing, because unlike an ordinary interlocutory injunction, as I go on to show in a moment, the freezing order does not look to the rights. It's not asserting or protecting the rights in the underlying proceedings. It's looking to protect the enforcement process once and if a judgment is obtained. We also say, more broadly, of course, that the reason why it should become involved is because that is what international financial centres do these days. And the idea that one turns a blind eye to such conduct is simply not considered acceptable. And one can see that when one looks at the legislation that's been adopted in the various countries that have faced the impact of the Susquehanna and Mercedes-Benz reasoning. They've all, in one form or another, adopted some means of overcoming those restrictions and providing such relief. I've dealt with the issue of the no procedural fairness arising from this because of the tightly controlled and regulated self-contained regime. The fact that at the end of that regime, there is not a definitive answer on the questions such as risk of dissipation, etc. That happens in every case of a freezing order, whether the underlying cause of action is domestic or foreign. The freezing order acts on a good arguable case on the merits, and it acts on sufficient evidence to show a real risk, solid evidence to show a real risk of dissipation. The trial is likely to have absolutely nothing to say about the real risk of dissipation, and its relevance on good arguable case would simply be whether or not a judgment flows from it. And yet, so we say the absence of a trial isn't a basis for concerns in adopting this position. It's no part of this appeal to alter the type of putative judgments which may be enforceable in the BVI. So you'll only be getting a freezing order over the type of judgments that the BVI as a jurisdiction has decided it should give a freezing order relief in and has decided that it is enforceable. The trial, as I say, is a trial not of the entitlement of the freezing order, but of those underlying rights, which, in my respectful submission, do not bear on the entitlement to the freezing order jurisdiction. The BVI court retains full control over the granting of the freezing order. It decides, it alone decides, whether to grant that relief or not. The process by which the issue of the merits, the good arguable case, is decided is the same, irrespective of whether the underlying cause of action takes place in the BVI or abroad, it's on an affidavit. One doesn't call live evidence in a freezing order. One satisfies the requirement, which is a relatively low threshold in any event, but by reference to affidavit in both scenarios. So we say that the absence of a trial within the BVI is no more a cause for concern than its presence is a reassurance as to the issue of the protection of the interests of the respondent. And the appropriateness of proceeding with injunctive relief, whether ordinary interlocutory or, as we're focusing on these appeals, a freezing order jurisdiction, within the BVI, whilst the substantive trial takes place in another forum, whether it be another jurisdiction or another forum by way of arbitration, has been settled in the Channel Tunnel. So the Channel Tunnel, although it with respect tips the hat to the Susquehanna by its dancing on a pinhead about power, unexercised power that it hasn't asserted but could assert, the upshot of that case is that there is no need to control the underlying proceedings, the substantive proceedings, in order to have the power to grant interim relief in aid of them. And when one turns to legislation, it's unlikely, my lords, that we will have much opportunity to look at the legislation in the other jurisdictions in any detail, but we do run through them in ours and my opponent's various statements of case. But the legislation that's been adopted is all quite simple. There's no international issues that arise. You don't reveal any practical difficulties. The BVI recent legislation on the power issue was adopted very speedily after the Court of Appeal decisions on New Year's Eve. There's no suggestion that such legislation is riding your coach and horses through any constitutional principle, etc. And ultimately, my lords, although we will be urging the board to adopt a position based upon the best traditions of common law development as opposed to legislation, when you look at the legislation and asks oneself, who's doing what here? Where's the heavy lifting being done? It's being done by judges afforded a very wide discretion, whether it's used based on the wording expediency or the Cayman Islands legislation of just and convenience. It's to be built up in the best traditions of the common law by a judge or judges over time, meeting issues and addressing them. There's no careful framework that's been imposed by any of this legislation, which wouldn't be available to your lordships if you were to accede to these appeals. The job, the heavy burden, is that of the judge, and that's the same as it would be in this case. So, my lords, could I perhaps take you to one extract from the UKOS case in the BVI Court of Appeal? I know that we will be focusing very heavily on the line of English authorities for the obvious reasons. So it's perhaps worth at a very early point to just mark up. We say if one turns to 13344, and paragraph 147, a few lines down, this is in the UKOS matter, that's Mr. Justice Kwai. And about 5 lines down, he says, having made it quite clear that nothing he says in any way undermines the Black Swan jurisdiction, he says, the proper question is not whether a freezing order injunction is sought in support of either a local cause of action or a foreign cause of action, which has a local equivalent in any strict sense. Rather, the relevant inquiry is whether or not the claimant may obtain a foreign judgment which may be enforceable by whatever means against local assets owned or controlled by the defendant. And we say that that's exactly the question that ought to be asked. And in asking that question, Mr. Justice Kwai, we say, is in good company, because if one turns to Lord Bingham in the Fourier and LaRue case at 10598.
Mr. McGrath, Ms. McGrath, I'm sorry to interrupt you, but I think you must have turned off your video feed. We can't see you.
Some might say that's an advantage, my lord, but I must have knocked it by accident. I do apologise. My lord, while I'm just discussing
Thank you.
Is it fine? I'm just going to be giving the electronic bundle page references.
Yes, I think we're all working off electronic bundles.
So 10598, Lord Bingham, in the short introductory judgment in Foray, and he says, moreover or freezing injunctions were from the beginning and continue to be granted for an important but limited purpose, to prevent a defendant dissipating his assets with the intention or effect of frustrating enforcement of a prospective judgment. They're not a proprietary remedy. They're not granted to give a claimant advance security for his claim, although they may have that effect. They're not an end in themselves. They're a supplementary remedy granted to protect the efficacy of court proceedings, domestic or foreign. And then he says, in recognition of the severe effect which such an injunction may have on a defendant, the procedure for seeking and making moreover injunctions has over the last few decades become closely regulated. I regard that regulation as beneficial and would not wish to weaken it in any way. The procedure incorporates important safeguards for the defendant. One of those safeguards, by no means the least important, is that the claimant should identify the prospective judgment whose enforcement the defendant is not to be permitted by dissipating his assets to frustrate. Now, just pausing there for a moment, he doesn't. He's not describing a need to identify the underlying rights. The key part of the procedural concerns he's referring to here is by reference to a prospective judgment whose enforcement the defendant is not to be permitted by dissipating his assets to frustrate. The claimant cannot, of course, guarantee that he will recover judgment, nor what the terms of the judgment will be. But just pausing there, insofar as it's said against me, but you have no control over the outcome of the foreign proceedings, and neither does the BVI court. And what if it turns out that you fail miserably abroad and no such judgment comes in? Well, that's not a principled argument against the jurisdiction, because that happens all the time, whether one would be domestic or foreign proceedings dealing with the underlying cause of action. And the carefully crafted procedure with possible takings and damages, etc., will be able to work out whether or not the applicant for the freezing order must now pay for the interference ahead of a judgment in the handling of the assets of the defendant, and if so, what losses have flown from that interference. But that is what happens all the time. So it was said, I think, against me by broad idea that it may be that at the end of the day, you have no assets left in the BVI to justify having had the freezing order. Well, yes, if the freezing order has done its job and has prevented wrongful dissipation, and when I use the word dissipation, I use it in the correct sense of unjustifiable dissipation, as opposed to just happenstance of using it. If it's prevented wrongful dissipation, it's still possible that the assets in the BVI are spent because they're being used for legal fees and business expenses or ordinary living expenses. That, again, is an occurrence which happens and is dealt with on a daily basis with judges who give out this sort of relief. But so he says the claimant cannot, of course, guarantee that he will recover a judgment, nor what the terms of the judgment will be. But he must at least point to proceedings already brought or proceedings about to be brought, so as to show where and on what basis he expects to recover judgment against the defendant. So the focus is all on the likelihood of a judgment, where it might be enforced, and why, therefore, that jurisdiction needs to be engaged. And the final case in this line I wanted to take you to is Mercedes-Benz at 11760. At E to H, E to the end of G. This feature has to be, although normally granted in the proceedings in which the judgment is being sought, waiver relief is not granted in aid of the cause of action asserted in the proceedings, at any rate in an ordinary sense. It is not so much relief appurtenant to a money claim as relief appurtenant to a prospective money judgment. It is relief granted to facilitate the process of execution or enforcement which will arise when, but only when, the judgment for payment of an amount of money has been obtained. The court is looking ahead to that stage and taking steps designed to ensure that the defendant cannot defeat the purpose of the judgment by thwarting in advance the efficacy of the process by which the court will enforce compliance. He is not to be permitted to steal a march on the court's own enforcement process. If a prospective judgment debtor can look and plan ahead, so can the court. He's not at liberty deliberately to take steps to prevent enforcement. This is so irrespective of the nature of the underlying cause of action. Waiver relief is granted in aid of the underlying cause of action only in the sense that the whole enforcement process can be said to be in aid of that cause of action. So, my lords, I stopped there because it's said against me that I'm wrong to say that the underlying rights are irrelevant to the freezing order jurisdiction. In my respectful submission, that's not correct. The nature of those rights is typically irrelevant. I say typically because I accept that there can be circumstances where one relies on the nature of the claim in order to provide evidence of risk of dissipation. But there isn't an inherent connection between the rights in dispute and the need for a freezing order. So to give an example, one could have a run-of-the-mill breach of contract claim, which leads to a damages claim against a defendant who, within the context of that contract, hasn't done anything untoward save he's alleged to have breached terms, but that he has a history of not paying other judgments or a history of putting his assets beyond reach. The freezing order will be all about that conduct, none of which will be relevant for the purposes of determining whether there's been a breach of contract. So it's not that one can't look to the rights for any assistance. It's that there is not, as we say, the Susquehanna said that there was, a need for a specific, clear relationship between those rights in dispute and the ability to obtain a freezing order. That may exist in respect of an ordinary interlocutory injunction, but it is not the role and function of a freezing order jurisdiction, freezing order injunction. So turning then, my lords, to the analysis of the freezing order jurisdiction, and I've briefly touched on this, but just the importance of language. I'm happy and do use standalone, so long as it doesn't lead to confusion that there's any closer, legally, any closer relationship between the freezing order and an underlying cause of action in the BVI, as opposed to the freezing order and a foreign set of proceedings. The relationship is and always is between the freezing order and the putative enforcement process in the BVI. Even when one is dealing with a foreign set of proceedings, you would only justify the intervention of the BVI to grant a freezing order in respect of conduct relating to its own enforcement process, when there is a need to prevent such conduct, and that is when its own enforcement process is invoked. So there is a danger that one looks and uses the shorthand of standalone or freestanding and believe that the freezing order is doing something substantially and legally different from what it does every day of the week. What happens, however, and what did happen in the Susquehanna, and perhaps not surprisingly, is that by the time the case got to the Susquehanna, there were only 3 reported cases on the Susquehanna, on the freezing order jurisdiction, all of which involved, not surprisingly, as a fledgling jurisdiction, domestic set of proceedings and domestic assets and a foreign defendant. So there was a perception that that factual scenario was the outer limits of the freezing order jurisdiction, which it isn't. And similarly, in aid of foreign proceedings, that is something as well to keep an eye on, because yes, one does not want to involve oneself in the affairs of another court's ability to deal with the underlying substantive claim. And what we're envisaging as a standalone freezing order under the gateway would be a freezing order which is focused on the protection of the BVI enforcement process, not interference with foreign proceedings. But of course, in light of overall comity and the natural discretion, the court would bear in mind, make sure that it does not take steps which are considered inappropriate, unwelcome, etc., by the foreign court. That is the sort of thing that a judge in the Chancery or Commercial Court facing international litigation does on a regular basis. It's nothing to do with political issues and international treaties or what have you. It's to do with just recognising the proper scope of the relief, what is needed, and whether or not you're acting as a good neighbour when providing it. But the focus, when we identify it as being the protection of one's own enforcement regime, takes some of the sting away, the idea that actually you're interfering with a foreign set of proceedings, because you're looking at conduct that has nothing to do and is not connected with the underlying rights in the foreign set of proceedings. So we say, my lords, as I said at the outset, that the freezing order has always been fundamentally inconsistent with the traditional analysis of an ordinary interlocutory injunction. And your lordships will see our analysis in the statement of case at paragraphs 53 to 69, and as regards to the differences between it and the American cyanamide injunction, which is the shorthand I've used for ordinary interlocutory injunction, is paragraph 70 to 93. If we just pause here, my lords, a great deal of what I'm submitting and will be submitting to your lordship is remarkably uncontroversial. To a certain extent, some aspect of the thrust of my submissions is that there's been a failure to grapple with what is well-established understanding of what the freezing order does. So that what we're trying to do here is to say, now you need to grapple. For the reasons I've explained and will show, the freezing order managed to slip through the guillotine of the Susquehanna. We've indicated in our statement of case the concerns that were expressed at the time by Lord Denning. He knew exactly what was happening. He knew, well, I'll reserve those comments to when I get on to that, but he knew what he was doing, and he knew what he did not justify legally the freezing order. And he managed to get it past the House of Lords. He was willing to forego service out to save the baby. The bathwater went out, but the baby was saved. And then it became well established. And now, as I stand before this board, I stand not in the same position as Lord Denning did, worried that you may, if you don't like my arguments, get rid of the freezing order jurisdiction. I'm standing here fully confident that isn't on the agenda. But I can say to you that what's happened is that in this day and age, we now have a freezing order on the one hand, justified by one set of rules, and reasoning which is completely inconsistent with it. And that's a conflict. And the answer to that conflict might be that the board says, thanks very much, Mr. McGrath, very interesting, but the Susquehanna was absolutely right. That would be useful, because at the moment it's not very well loved. And most decisions, even up to the House of Lords or the Supreme Court, start with some suggestion that we're not going to look at the principles in the Susquehanna unless we have to. We recognise to be modified, but it's still standing and it's still law. My goodness, the love that comes out from the senior judges for the reasoning in that case is remarkable, but it needs to be grappled with now. And we say the crucial difference, there's loads of differences, it's manifested, but the crucial difference is that the ordinary interlocutory injunction is intended, as was presented in the Susquehanna, to preserve and protect the very rights which are the subject matter of the determination in the underlying claim. I think in the statement of the case I gave a ridiculously simple example of a tree and a dispute between neighbours about whether or not one could chop it down or cut it back or what have you. Obviously, one needs to first determine who owns the tree and has the rights over the tree. So an interlocutory injunction that freezes everything going on, I shouldn't have used the language freeze, that stops any irretrievable damage to the tree pending the outcome of the determination of the ownership, is an interlocutory injunction which is inextricably justified and linked with the rights that are being asserted and disputed in the underlying claim. That's not, for the reasons I gave in the simple breach of contract claim, the position in respect of the freezing order. Lord Nichols made that point in the Mercedes-Benz, and in fact, Lord Mustall, in the majority in the Mercedes-Benz, says something quite similar at 11756. So he begins at the top there. Thus, at the centre of the powers conferred by Order 11, it's a proposed action or matter which will decide upon and give effect to rights. An application for Moravian relief is not of this character. When ruled upon, it decides no rights and calls into existence no process by which the rights will be decided. The decision will take place in the framework of a distinct procedure, the outcome and course of which will be quite unaffected by whether or not the Moravian relief has been granted. Again, if the application succeeds, the relief granted bears no resemblance to an orthodox interlocutory injunction, which in a provisional and temporary way does seek to enforce rights, or to the kind of interim procedural measure which aims to make more effective the conduct of the action or matter in which the substantive rights of the plaintiff are ascertained. That's the role of the injunction, the interlocutory injunction. Nor does the Moravian injunction enforce the plaintiff's rights, even when a judgment has ascertained that they exist, but it merely ensures that once the mechanisms of enforcement are set in motion, there is something physically available upon which they can work. So, my lords, both sides in the Mercedes-Benz were well aware of the distinction between an interlocutory injunction of an American Shanamid nature and a freezing order, and that the interlocking between the underlying rights and the nature of the relief simply doesn't arise. And when one can make good that point, when one looks further down the line as to the American Shanamid criteria that simply wouldn't apply to freezing order, assessment of adequacy of damages is based upon the violation of the rights that are in dispute. Who would be worse off? That's simply not something that's discussed at all, or would be relevant for the purposes of a freezing order jurisdiction. Preservation of the status quo. Now, this came, you'll see this is in play in the Susquehanna. But status quo preservation, whatever the rights or wrongs technically and precisely of its application to an interlocutory injunction in the ordinary form, has no application really to a freezing order jurisdiction, because, as I've said, the outcome of a freezing order could very well be that the pot of gold is properly dissipated in the ordinary course of business and ordinary business expenses without any breach of the freezing order at all. And even if one takes it as far as the orders on an American Shanamid level, they're bespoke. Why are they bespoke? They're bespoke because they need to be fashioned in order to protect the particular rights that are in dispute in the underlying claim. And those rights can be of all sorts of forms and nature. If it's about a tree, it's what's intended to be done to the tree, then becomes the kind of action that is being prevented. But in a freezing order, we have a standard form. And the reason why we have a standard form, which is subject to detailed committee scrutiny and boundaries being pushed constantly in the Chancery and Commercial Court as to appropriateness. The reason we have a standard form and can have one is because it is focused on specific conduct, wrongful dissipation. Where it's tweaked is to take into account nothing to do with the underlying rights, but how assets are held, because it needs to evolve to meet the new asset protection structures and foundations and what have you, and especially trusts that are now the basis upon which assets are held. But that's looking at assets that may have absolutely nothing to do with the underlying dispute. That's where it's tweaked, but it is standard because it's looking at one type of harm. So when having noted in my submissions the difference between the two, one can see that when the freezing order was first proposed and considered, and we note from the cases that there were many attempts to get it through the gate, which didn't succeed. And the reasons why they didn't were twofold, but in fact, there is a connection between the two. The first is the decision in Lister and Stubbs. Now, it's no relevance to my submissions that we now, under English law, have seen the light and gone back to Attorney General Hong Kong and Reed that a bribe is held under constructive trust. That wasn't the position then, nor does that change in the law make any difference to the force of these submissions. But he had to, it was the list, and the second decision is North London Railway, Great Northern Railway, which is the key to the Susquehanna. It is the key because it is the reasoning that is relied upon in the Susquehanna. And we say that the freezing order jurisdiction does not focus on a right in an asset or a right to an asset. There's no claim to a tree here, or a right to control conduct in relation to the tree. And that's where it came up against Lister and Stubbs and the established principle of English law that a person is entitled to deal with his own assets, whatever he wanted to do, prior to the determination of any debt claim against him. So the fact that you might have a debt claim did not give you a right to protect his general assets, which is exactly, obviously, what a freezing order is intended to do in its most basic form. And on the facts of that case, your lordships will no doubt be well familiar with the very simple facts that the claimant's foreman took a bribe and invested some of that bribe money. And the claimant brought a claim to recover the bribe money, but most importantly, for present purposes, brought an application of an interlocutory injunction to restrain the foreman from dealing with those assets ahead of any judgment on the debt. And the case, the Court of Appeal, Mr. Justice Sterling said, refused the injunction, and his refusal was upheld on appeal. If the money had been held on trust, as we now would say, then there would be a right to the trust monies, whether based on constructive or resulting trust. We can leave that debate to one side, but there would be a right to the monies, which then the freezing order or the interlocutory injunction would be said to be supporting, and we would be right into it, ordinary reasoning of interlocutory injunction. But in the absence of such right, there is no connection between the freezing order and the underlying assets ahead of any debt claim. And therefore, it was no surprise that the freezing order, the injunction, as it was called, the interlocutory injunction, was refused. And the judge that decided, or one of the judges, there's only two in that Court of Appeal, one of them was Lord Justice Cotton. And it's perhaps worth noting that this is 1890, some 7 years after Lord Justice Cotton decided North London Railway in 1893. And one will see the significance of North London Railway in a moment. But what's palpably clear is that Lord Justice Cotton would never have granted a freezing order. He wasn't granting this interlocutory injunction because it didn't have the connection with the underlying debts. And the importance to the recognition of the freezing order of this point can be seen from Lord Hailsham in the Susquehanna. Now, one spends so much time looking at Lord Diplock, one sometimes forgets that Lord Hailsham was there as well. And it's Lord Hailsham, and it's at page 12837. And he says there, at E, 3 years ago, I'd have regarded the respondent's case as wholly unarguable. I believe it to be settled law to employ the language of Lord Hatherley. And then he quotes, and one can see down at G, you cannot get an injunction to restrain a man who is alleged to be a debtor from parting with his property. And he also quotes Lord Justice Cotton in Lister and Stubbs. And then at H, he picks it up and says, now, however, this well-established list of authorities to the effect that an unsecured creditor cannot convert himself into a partially secured creditor merely by bringing in an action against the alleged debtor and then seeking to freeze his assets by an injunction is apparently no longer reliable, at least as regards foreign-based defendants with assets in this country. And he refers to 3 cases there, the first 3 Moraga cases. While we're on it, and instead of coming back to the point, you will see if we pick it up, and at B, he says, so far, such injunctions seem to have been confined to the commercial list and perhaps entirely to shipping cases. Well, that's obviously no longer the case, except in the event, which is not happening, that we were otherwise disposed to dismiss this appeal. We were not invited to override this new and creative line of authority. But speaking for myself, I was at one time disposed to think that if the right to an injunction was still as flexible a remedy from these cases it now appears to be, there was little reason why it should not be extended further to protect the position of the present respondents, in favour of whom one must assume, owing to the way in which the argument has gone, without in the least deciding the matter, that they possess all the merits. I am, however, persuaded, for the reasons given by my noble and learned friend, that this would not be legitimate and that the appeal must therefore be allowed, as he has proposed on the grounds which he has given. Now, just pausing there, what we have is, firstly, the recognition of the stark conflict between the line of Lister and Stubbs line of authorities and the very existence of the freezing order. A belief now that that's been trammeled upon, apparently, as it no longer is reliable. But a recognition, then noting that we would only engage in the issue if we dismissed the appeal, which meant that they allowed service out. At that point, then, counsel, Mr. Lloyd QC, wanted to argue that the whole thing should be chucked out. So, if they were going to allow service out, that he was going to challenge the whole nature of the freezing order. That didn't happen. But he says, if it's as flexible as these cases say it is, then I'd be minded to have allowed the whole thing, but I've been persuaded otherwise. Now, yes, of course, we can point that he'd been persuaded otherwise, but here is a judge in the Susquehanna recognising, in my respectful submission, that if you accept the existence of the freezing order jurisdiction contrary to Lister and Stubbs reasoning, then he would not only recognise standalone, but he was going to allow service out of the jurisdiction. And there's not a word in anything he says about any constitutional difficulties, etc. Now, I appreciate that's not what he did, so I'm not pushing it too far, but that's what is in his mind, and he felt strongly enough to record it in his judgment. So that's Lister and Stubbs as an obstacle. And then secondly, we have North London Railway and Great Northern Railway. And in this case, my lords, if we can go back to, because it does form an important part of the reasoning in the Susquehanna. And if we begin at 11902, we have Lord Justice Brett, the other judge in the case. The background here, my lords, is of course whether or not they should stop what appears, and they've characterised as a futile, void, useless, not going to cause anyone any harm arbitration. And their view is that because it's not going to cause anyone any harm, we need not stop it. Perhaps not the view that would be taken now, but that's the view taken there. And we see that in 38, towards the end of Lord Justice Brett's reasoning. And he says, what we're asked to do is take away from the appellants their power of election, if there be any, and to enjoin them against proceeding at their own risk and at their own expense, without injury to anybody, in what, for the purposes of this judgment, we must assume to be an entirely futile arbitration, which would not injure anyone but the appellants. Therefore, it seems to me that the injunction which is now appealed against cannot be sustained, and that this appeal ought to be allowed. Now, just pausing there, that without getting into underlying rights and that discussion, and just looking at what was the thrust of the reasoning here, it is no harm, no reason to interfere, therefore no basis for an injunction. Well, it's very difficult to, on that characterization of the absence of harm, very difficult to criticize. There'd be no basis for an injunction. But one can readily distinguish that kind of scenario which drove the reasoning in Great Northern Railway from your fact scenario of a freezer order, where palpably one could not sit back if you've got a real risk of dissipation and allow those assets to go and say, no harm. You've got no worries at all if those assets go. That simply couldn't arise. So then we turn to Lord Justice Cotton, and about midway down that first paragraph on 11902, he said, we desired the question to be argued first whether the court had power to grant an injunction, and in my opinion, it had not such power. And then a little bit further down, he says, of course, it's very inconvenient for anyone to be brought before a tribunal which has no jurisdiction. Does that give a right to the High Court to interfere? Undoubtedly, it could hardly have been contended that in such a case before the Judicature Act, any court would have interfered by injunction to restrain a party from going on before arbitration. And if one slips down about halfway down, he's given the wording of section 25 and then goes, if it was intended to give that the enormously increased power which it is contended is given by this section, it is remarkable that it empowers it to be done by interlocutory order. It's said that if it can be done by interlocutory order, of course it can be done by a final order at the hearing of the cause or judgment. No doubt that's true. But when this section only refers to interlocutory order and not to orders for injunction to be made at the hearing of the cause, it is not the prima facie presumption that it did not intend to give the right to an injunction to parties who before had no legal right whatever, but simply to give to the court when dealing with legal rights which were under its jurisdiction independently of the section, power, if it should think it just and convenient, to superadd to what would have been previously the remedy, a remedy by way of injunction, altering therefore not in any way the rights of parties so as to give a right to those who had no legal right before, but enabling the court to modify the principle on which it had previously proceeded in granting injunctions, so that there is a legal right, so that where there is a legal right, the court may, without being hampered by its own rules, grant an injunction where it is just and convenient to do so for the purpose of protecting or asserting the legal rights of the parties. That, in my opinion, is the real meaning of this section. In my opinion, all that was done by this section was to give to the High Court power to give a remedy which formerly would not have been given in that particular case but still only a remedy in defence of or to enforce rights which, according to law, were previously existing and capable of being enforced in some or one of the different divisions which are now united in the High Court. And then at the last sentence of that paragraph, in my opinion, the sole intention of the section is this: that where there is a legal right which was, independently of the Act, capable of being enforced either at law or in equity, then whatever may have been the previous practice, the High Court may interfere by injunction in the protection of that right. So, my lords, it's quite clear that the thinking and the reasoning of Lord Justice Cotton in North London Railway is that it's possible to obtain an interlocutory injunction only to remedy an existing right which the court can otherwise enforce and recognise. So there is a connection between the interlocutory injunction being in aid of protecting and asserting the rights that are in dispute, and that then in the Susquehanna is asserting rights that are in dispute, i.e. in the underlying claim. And that is the connection between an interlocutory injunction and the underlying claim. One cannot have an interlocutory injunction on this reasoning. I'm not at this point talking about any modern cases that have danced on a pinhead as to ways of getting around, but on this reasoning, he's saying you need to connect the entitlement to the interlocutory injunction to existing rights that are would have been before one or other of the divisions before the Judicature Act. And we say, well, that plainly is not freezing order. And one could approach this case by saying, well, doesn't that cause you some difficulties then, Mr. Murad? Because if I was trying to persuade you to grant a freezing order for the first time, yes, but the reality is the freezing order now exists and has been allowed to develop, but plainly does not do that job. Certainly not in the way Lord Justice Cotton is suggesting, and as I've indicated in my submission so far, it's looking in a different direction. It's looking at the end of the proceeding and enforcement. And I just make the point that this is obviously not a service out jurisdiction case. I make that point because one will see just how important and influential as a case it seems to have played in the Susquehanna, the reasonings to support the approach to the injunction gateway. And I've already addressed your lordships, and we did in our statement of case, that the underlying fact scenario, no harm, therefore no injunction, simply bears no relevance or application to a freezing order, because one can recognise harm, which is now a well-established reason for action by equity, I can use that language, to impose a freezing order, now well-established, to do with dissipation of assets, which has nothing to do with the applicant's right to those assets or a dispute about those assets. But that is now well established and is the freezing order jurisdiction. So what's happened is that you've got the North London Railway reasoning, but we've actually got the development of the freezing order, which is now very much taken on life of its own and has developed parallel or separate to, occasionally coming into conflict. Much of that conflict is a matter of English common law having been avoided by way of the Section 25 enactment, but nevertheless coming into contact and conflict and having to be sorted out at other stages. And we see it in the difficulties about a pre-existing course of action. It's all tied up with that. Section 25 in England no more answered those questions than the BVI legislation would do in the BVI, and the other legislation around the world in other offshore jurisdictions has done for them. So one could see that there is a plain inconsistency between both Lister and Stubbs and North London Railway in the very existence of the freezing order. So one might reasonably then say to me, how on earth did this beast get set free in the English court in the light of these submissions, if what you're saying is true? Now, my lords, if we can go on that to tackle that point, if we can deal with the first case, I just wanted to show you Nipper-Newson and the Morava case itself. The first one is Nipper-Newson at 11868. It is a very short judgment, and I just wanted to show you Lord Denning's reasoning from H on 11868. And he says, we're told that an injunction of this kind has never been granted. It's never been a practice of the English courts to seize assets of a defendant in advance of judgment or to restrain the disposal of them. We were told that Mr. Justice Chapman and Chambers recently refused such an application. In this case also, Mr. Justice Donaldson refused it. We know, of course, that the practice on the continent of Europe is different. It seems to me that the time has come that we should revise our practice. There is no reason why the High Court or this court should not make an order such as is asked for here. It is warranted by Section 45 of the Supreme Court Act, which says that the High Court may grant a mandamus or injunction or appoint a receiver by an interlocutory order in all cases in which it appears to the court to be just and convenient so to do. It seems to me that this is just such a case. There's a strong prima facie case that the hire is erring and unpaid. If an injunction is not granted, these monies may be removed out of the jurisdiction, and the ship owners will have the greatest difficulty in recovering anything. 2 days ago, we granted an injunction ex parte, and we should continue it. So he's effectively saying this is a good thing to do. Section 45 is nicely wide wording. We're doing it. And no mention in this case, as one can see, of Lister and Stubbs or North London Railway. Turning then, if we may, to Morava itself, at 11594. And in this case, starting on the left-hand side, it says it's all about monies in a bank in London. And then he says, about halfway down the middle paragraph, so they've applied for an injunction to restrain the disposal of those monies which are now in the bank. They rely on the recent case of Nipper-Newson Kaisha. Mr. Justice Donaldson felt some doubt about that decision, perhaps not rather understandably, given the absence of the citation of Lister and Stubbs. And there were observations in that case to the effect that the court has no jurisdiction to protect the creditor before he gets judgment. And then he quotes Lord Justice Cotton. I know of no case where, because it was highly probable that if the action were brought to a hearing, the plaintiff could establish that a debt was due to him from the defendant has been ordered to give security until that has been established by the judgment or the decree. And that's Lord Justice Cotton in Lister and Stubbs. And Lord Justice Linley says we should be doing what I conceive to be a grave mischief if we were to stretch a sound principle to the extent to which the appellants ask us to stretch it. And it says Mr. Justice Donaldson felt that he was bound by Lister and Stubbs and that he had no power to grant an injunction. But in deference to the recent case, he did grant an injunction on limited terms. Now Mr. Ricks has been very helpful. He's drawn our attention not only to Lister and Stubbs, but also to Section 45 of the Judicate Act, and then he quotes that. And in Beddoe and Beddoe, Sir George Jessel, the then Master of Wills, gave a very wide interpretation to that section, where he said, I have unlimited power to grant an injunction in any case where it be right or just so to do. Just pausing there, I should say that Beddoe and Beddoe was subject to review by Lord Justice Cotton in North London Railway, and Lord Justice Cotton characterised or recharacterised what he was saying as, I believe what he was saying was that he could do this if there was a legal right that was being enforced and protected by the interlocutory injunction. So he brought Beddoe and Beddoe back to reasoning which would be consistent with North London Railway in his own mind. Although, as both Lord Scarman and Fraser in the Bremer-Vulcan case pointed out in the House of Lords, he was very clear that's what he was doing, but very unclear what the legal right was that was being protected in Beddoe and Beddoe, and was it just simply the right to natural justice because they were dealing with a corrupt arbitrator. He didn't spell out. One might say, with respect to Lord Justice Cotton, that it's all very well bringing it back to your reasoning, but let's see the colour of your money. What is the right that you're saying is being protected? And if we engage in that process, one might ask, on one basis, how far away is that from protecting any other aspect of the process of natural justice? Natural justice doesn't end with the civil proceedings trial process coming to an end. It must include the enforcement process. Otherwise, and in fact, critically, I'm saying that, if it didn't, why on earth engage in the game in the first place? It's a waste of money. The judgment that would come from the court wouldn't be worth the penny it was written, the paper was written on. So we need to protect that enforcement process. And then he says, there's only one qualification to be made. The court will not grant an injunction to protect a person who has no legal or equitable right whatever. That appears from North London Railway. But subject to that qualification, the statute gives a wide general power to the courts. So he's ignored Beddoe and Beddoe recharacterization. And then he says, in my opinion, that principle applies to a creditor who has a right to be paid the debt owed to him even before he has established his right by getting judgment for it. Now, that's how Lord Denning tries to square the circle here, by saying that there's a right to be paid a debt before one establishes that the debt, in fact, exists. We can argue about that all day long. What I can say right now is that this justification, plus the other justification that Lord Denning brings out, which I'll show you in a moment, were both rejected by Lord Mustall and the majority in Mercedes-Benz. Simply did not work, he said. And again, if I was trying to argue and persuade your lordships to grant a freezing order for the first time, I'd be in difficulties, because someone would be saying, well, the reasoning that you're now relying upon has been shot out of the water. Firstly, it wasn't very convincing to start with, Mr. McGrath, and secondly, it's now been shot out of the water by the majority in Mercedes-Benz. The problem is with that is that what does it leave? Lord Mustall, as we'll see, said there's only two rationales put forward in the cases. One was this argument, a right to be paid, a debt before the debt's been established. And the other one was the revival of the old city attachment of assets. And the attachment of assets fell foul of the fact that we're not attaching assets. That has a real problem with that one. And this one falls foul of the fact that how can you have a right to a debt when you haven't established a debt? So what does that leave? And it's one of the submissions I'm going to be making to your lordships, that actually, and it's always dangerous to think beyond what's actually written. But when one looks at Lord Mustall's judgment or speech as a whole, or opinion as a whole, in Mercedes-Benz, and when he says, if Lord Nichols's analysis in the future case is adopted, we'll need to reconsider service out. One does wonder whether he understands the precarious status of the freezing order as justified by reference to the Susquehanna reasoning. And because it by then had become much more established, there was no possibility of the freezing order being kicked out and being challenged root and branch. And so one would then be facing a real challenge with the reasoning in the Susquehanna. And my lords, just for your reference, it's Lord Mustill at page 11754 in Mercedes-Benz. So we may have time to return to that. My lords, I see it's coming up to 11:45. I'm about to go on to the Susquehanna, so I wonder whether that's a sensible moment.
Yes, thank you, Mr. McGrath. In that case, we'll adjourn for 5 minutes. Thank you. I think we're ready now to resume. Mr. McGrath.
My lord, turning now to the Susquehanna, and as I indicated in the short overview of how we got here, I referred to concerns about the possibility of a full frontal challenge to the freezing order in the Susquehanna appeal. And just for your lordship's note, Lord Denning expresses those concerns and how grateful he was to the skill of Mr. Lloyd QC when he was presenting his submissions in the due process of the law. And for your note, it's 14289 of the bundle. And we know from Lord Hailsham and also from Lord Diplock, but we know from Lord Hailsham, from this extract I've already shown you, that in the absence of dismissing the appeal, there was not going to be a full frontal challenge, and therefore no detailed analysis of the freezing order. Now, my lords, there's often a tendency with cases such as the Susquehanna to jump straight through to, we'll probably know the page reference of the judgment by heart, and just look at the 2 paragraphs and spend ages trying to discuss that. But actually, to be fair to the House of Lords and Lord Diplock, it's important to see how the case was developed through the lines up from Mr. Justice Carr, the Court of Appeal, and then obviously in the House of Lords. And with that in mind, my lords, can I begin at 12793 in the judgment of Mr. Justice Carr? And one consistent theme that your lordships will see throughout the judgments of Mr. Justice Carr, Lord Justice Bridge, and also Lord Diplock, is a recognition of the factual scenario that the first 3 cases all happen to involve causes of action that were before the English court, and I've made my submissions on that. But it's worth noting that that's present in all 3. An additional reason for looking at Mr. Justice Carr and also Lord Justice Bridge in the Court of Appeal, who dissented, is of course that Lord Diplock made it quite clear that he was in agreement with those 2 judgments as well. So I hope it's a useful exercise, although it may be one that requires an element of speeding through the judgments in time. So at 12793H, he makes that point that in the cases so far, the defendants have been properly served in an action on the merits through to the next page on 12794. And then if one turns to 12796, at E to F, he makes the point that the claim for damages in the Susquehanna did not fall within the contract damages gateway. That's not controversial. But he says there that the authorities establish, this is at F, the authorities establish that in a writ served out of the jurisdiction, it is not permissible to include, either originally or by way of an amendment, claims which do not fall within any of the sub-rules of Order 11. And this really is that pentitio, if I pronounce it correctly, petitio principi that Lord Diplock identifies in his judgment, namely using the interlocutory injunction as a means of getting through the back door an underlying cause of action which would not otherwise be subject to the jurisdiction of the English court. And he's saying that there, and he's challenged on that by Mr. Ricks. And if one turns over to 12797 at B, he says, I therefore hold that even if there's jurisdiction under sub-rule I, which is the injunction rule, the claims for damages and interest must be struck out of the writ, so that the only maintainable claim would be the claim for the Morava type of injunction. Now, just pausing there, throughout the arguments at all levels of the Susquehanna, the ship owners put their case on two fronts, as we've seen. One was a standalone injunction. That was the second argument. The first argument was an injunction which enabled you to bring with it the underlying cause of action. And what Mr. Justice Carr is saying here is that you can't bring with it an underlying cause of action that doesn't fall within its own gateway. Now, it forms no part of this appeal for us to contend that by granting injunction service out over the freezing injunction, that one is in any way asserting jurisdiction over an underlying cause of action. We don't say that. Mr. Ricks then at E on 12797 says his argument was simple. He said that with or without the claim for damages, this is an action in which an injunction is sought, ordering the defendant to refrain from doing something within the jurisdiction, with the result that the case falls within the wording of the gateway. He therefore submitted that there was jurisdiction to make the order, this being the only question which I have to decide at present. And the contrary argument from Mr. Lee Jones was based on Rosler and Hilbury, and we'll see the extract there at H. And when one turns over the page at 12798, that extract from Rosler and Hilbury is challenged by Mr. Ricks at D. But one notes with some interest, and I ask your lordships to note, that Mr. Justice Carr refutes the challenge on the basis that he considers that it is properly summarised in Holsbury's statutes dealing with the note to section 45 of the Supreme Court Judicature. And that note said that it's contrary to established practice to grant an injunction, the claim to which does not arise out of and is not incidental to the cause of action in which it is claimed. So the reason I point that out is that it's part of our submission to say there is no separate principle of Rosler and Hilbury preventing service out of the jurisdiction. That one can see that Rosler and Hilbury is really the flip side, in the context of the freezing order, is the flip side of the argument, the need for a right. And here we see Mr. Justice Carr immediately jumping to section 45 and the note in Holsbury's in defence of reasoning in the Court of Appeal in Rosler. And he says at D that the summary was correct. And then, my lords, there's on the other side of Rosler and Hilbury, there's a case called Dreyfus. My lords, I'm not going to take time on Dreyfus before your lordships. Lord Diplock says it's a difficult case to understand. Lord Justice Bridge, if I can perhaps paraphrase, says it's a score draw on the authorities. Rosler on one side, Dreyfus on the other, nothing decisive. The argument in Dreyfus is whether one interprets what was going on there as a right to the assets in the fund, or whether it was simply a contractual right and therefore fell into the debt argument. And you'll see that Lord Denning relies heavily on Dreyfus. Otherwise, I don't think the answer to these appeals is going to lie in the reasoning in Dreyfus. Your Lordship should be aware that that is one of the cases that was relied upon in the run-up to the House of Lords. But you see the reaction to Mr. Justice Carr by Mr. Justice Carr 12799 at B, where he says, in my view, the fundamental distinction between those cases and the present one, so between Dreyfus and the present one, is that in both of them, the plaintiffs claim to be entitled to the assets in relation to which they sought an injunction. So we're back there to a Lister and Stubbs justification. for relief. And there are courts of jurisdiction to deal with the claim, the entitlement to the asset. The injunction which they claimed was therefore ancillary to a cause of action, which was also before the court, is the claim to the fund or other assets. And then he said the necessity for a cause of action as the basis for leave under Order 11 is clearly shown by Rule 4.1, which requires the application must be supported by an affidavit. Can I just interject there and say this, that with respect, whenever this point is thrown at me, it is not a justifiable principled reason why one should reject the arguments that we're putting forward, the fact that the affidavit requires this. But I ask this, when one, I ask your lordships to note that when one sees how the various jurisdictions operate under their new legislation, including the UK under Section 25, hey ho, you still have an affidavit for a freezing order on a standalone basis being served out, being required to satisfy the criteria for a freezing order, which is a good arguable cause of action. So it isn't a reason against the arguments put forward. But what one immediately sees is the reliance on North London Railway at D. And I won't go through what he cites, but it's important to see the role that North London Railway is playing in the thinking of Mr. Justice Carr in rejecting the case that a freestanding injunction would fall within the gateways. And what he says in 12800 at E, having shown that there's no claim in the underlying contractual damages that can come before the court because it's not with one of the gateways, he says, halfway down at E, in these circumstances, one is simply left with a claim for an interim injunction relating to a fund which the plaintiffs cannot and do not claim as such. Accordingly, since the writ contains no cause of action against the owners, at any rate for the purpose of Order 11, it is simply strikeable out. It follows that this is not a Mareva type case at all, but something entirely novel, and it might be contrary to principle, though it might well be desirable to confer upon the courts a discretionary power of this kind by legislation. Meanwhile, it seems to me that everything that's been said about the need for caution in giving leave under Order 11 applies in this case par excellence. So, having established that the underlying claim simply didn't get through the gateway, one is left with a freestanding interlocutory injunction as far as Mr. Justice Carr is concerned, and that freestanding interlocutory injunction is not something recognised in English law. Look at North London Railway. So we don't have the power to give it. Forget even serving it out of the jurisdiction. We don't have the power to give that kind of injunction. So then, turning to the Court of Appeal, and my Lord, beginning in logical order with Lord Denning, at page 12806, His Lordship, under the heading Mareva Injunction, effectively says it's all now well established. It's a great new thing. It's all very well established. One can almost sense the need to move on quickly. Just emphasise the key points. It does a good job. It's well liked and is well established now. And that's E to G. And then in H, dealing with leave to serve out, he deals with the reason why he says that between B and D, it falls within the injunction, and it's no more than the typical terse, succinct reasoning that one might expect from Lord Denning, namely that it seems to me, as he says at D, I must say that it seems to me that in our present case, the injunction sought falls entirely within the words of that rule. An injunction is sought by the cargo owners, ordering the ship owners be restrained from disposing of their assets within the jurisdiction, including and in particular the insurance proceeds in respect of the vessel Susquehanna. It's true that damages are claimed against the ship owners for breach of duty, etc. That's not necessary, but the rule applies whether damages are claimed or not. And then he goes through various objections that were raised by Mr. Lloyd QC. And just the first one, my lords, is another head of Order 11. And what's said here is if you need to fall within a gate, if the underlying cause of action needs to fall within its own gateway, service out, then what is the purpose, separate purpose and role of the injunction gateway? And that's what he's saying between E and G. Now, Lord Diplock endeavours to grapple with this argument. I hope I'm not being disrespectful in putting it that way, but it is grappling and no doubt great endeavour, but ultimately not very successfully, we would submit. And we would also add, my lords, to this point that there's also a suggestion of looking at the injunction gateway from the perspective of a cause of action gateway. And the injunction gateway is a relief-based gateway. So the focus, we say, should naturally focus on the relief injunction and not trying to establish the existence of an underlying cause of action, because the other gateways that are cause of action gateways, they themselves are expressly defined in terms of their cause of action and are gateways available based upon causes of action. So he then turns on 12808 to the substantive relief point, and Rosler and Hilbury. Well, we'll come on to this case in a moment, but the bottom line is, as he said there, I mean, there was an attempt there to obtain almost an abusive process to obtain an interlocutory injunction against, notwithstanding they'd already got a solicitor's undertaking, as a means of bringing an entirely inappropriate underlying claim into the UK when it should have been dealt with in Belgium, and plainly so. Now, clearly Lord Denning relies on that aspect of the judgment, and one can see in a moment Lord Justice Lawton also distinguishes Rosler on the basis of whether or not the application for an injunction is a genuine one. And when we have a quick look at Rosler, it's undoubtedly a case where, as Lord Diplock accepted, this point is obiter. And when you look at the thrust of the judgments, it's all about the underlying cause of action shouldn't be brought in the UK when plainly more suitable to Belgium. And of course, my lord, none of these concerns arise in respect of this appeal, because we are not seeking to bring the underlying cause of action in before the court at the same time as the feasible. And then, my lord, if I can maybe focus on 12810, which is the arguments on in aid of a legal right, which is, of course, very much the North London Railway point. And interestingly here, my lord, there's no attempt by Lord Denning to try and justify by reference to his reasoning put forward in Mareva of a right to be paid a debt that hadn't yet been established. In fact, he now just simply says that North London Railway is too narrowly stated. Now, as Lord Nusstel makes clear in Mercedes and Benz, that unfortunately that view of North London Railway has not been established and has been rejected in other cases. But that's the way he seeks to deal with it. And he refers to Spry, and your lordships have various extracts from Spry, which is a text that has been heavily relied upon in various cases, both here in the Susquehanna, but also more recently, in which it's been endorsed by the Court of Appeal, which talks about a much broader approach to the ability to grant interlocutory injunctions rather than the need for being in aid of or protecting a legal right. Now, my lords, I'm not interested in the community law point, and would just give as a reference the conclusion from Lord Denning, which your lordships may want to read at your leisure. I couldn't resist showing it to you. 12812 G down to the end of his judgment, where he really is trying to G up confidence in adopting the position that he suggests, and to the extent that any of that has any impact, I would rely on it before your lordships as well. Now, turning then to Lawton, Lord Justice Lawton, his judgment is, to a certain extent, is recommended for its simplicity. No attempt to try and overcomplicate matters. Just see it as it is. First off, he says at 12814, he says up at B to C, the writ contains an injunction. Says the claim for an injunction is genuine. It's not been put in the writ to give the appearance of being within the rule, as was the case in Roslow and Hilbert. So it follows that it's within the plain words of Rule 1. So plain meaning, and Roslow is distinguished on the basis that it's a genuine injunction. The next paragraph, he rejects Mr. Lloyd's attempt to engage in redrafting. I mean, I must say that one of the arguments said against us is that because we're asking for a different interpretation, we're asking for a redrafting, which I think is rather unfair when all we're really saying is the interpretation that had been given to the injunction gateways, or section 45 as then was wrong, and needs to be looked at. And I'm not the one asking for any words to be incorporated in anywhere. I'm not the one that needs to worry about how one drafts the injunction gateway. It's the other side, and for that I mean it's those supporting the Susquehanna reasoning. I don't mean my friends, but it's the other side who have to read things in to the statute and restrictions. And what's remarkable is from those who would say you should leave all this to legislation. My goodness, when legislation gives as wide wording as it did in section 45 and replicated thereafter, and judges decide on an act of self-denial to impose restrictions on that wording, then it's rather remarkable to say that if I then want to have a wider interpretation that's been accepted so far, I need a redrafting. What words do I need to add to fit my understanding of an interlocutory injunction in the form of a freezing order within section 45 or indeed 37? I say I don't. So he rejects the rewording. He does accept that North London is a more formidable obstacle, and he does that at F or 12814, and says unless the plaintiff's money claim is triable before the court, there's no substantive claim here to which the claim for an injunction can attach. This is all the North London Railway reasoning. The plaintiffs have no cause of action against the brokers, nor have they any rights enforceable against the assets within the realm, save by way of ancillary relief. And he says, however, he looks at the various gateways and can't define or discern any particular principle running through them. On the next page at 12815, he says, there does not appear at A, there does not purport to be any logical principle running through the rule, save that the subject matter of the claim or the defendant should be connected in some way with the jurisdiction. It is the existence of a specified situation which confers the jurisdiction, not the causes of action arising out of that situation. And then he looks at the injunction gateway, and he comes to the conclusion that I would construe the paragraph as meaning that if in an action there is a genuine claim for an injunction, a situation is created which enables the court to try all the claims in that action, including those which, if there were no claim for an injunction, would not come within the rule. Now, Lord, he favours, as we'll say, as Lord Justice Bridge, an approach that brings the kitchen sink in with the injunction. which is, of course, as I say, not our case. But of course, it is one of the reasons used against the appellants, the respondents to the appeal in the House of Lords in the Susquehanna. So it's important to bear in mind that some of the reasoning is to avoid the underlying cause of action being brought in that didn't otherwise fit within the gateway. So he said...
Can I just check with you, Mr. McGrath? Yeah. Am I right in understanding that your submission is that the North London Railway judgment was wrong? The Master of Rolls was correct in Beddoes. The effect of the 1873 Judicature Act was to expand the jurisdiction of the High Court to grant injunction.
My Lord, yes, but I temper it with this, if I may, and that is that I'm not in a position that I'm asking your lordships to recognise the freezing order, because then I would need to fit it into all the slots and overcome all the arguments. What I'm saying is it is now well established, and what is quite clear is that the criteria of the North London Railway, as it featured in the Susquehanna and moved on into the Mercedes-Benz, has no application to limit or restrain the availability of the freezing order jurisdiction. That it is a jurisdiction which plainly fell within the wide words of Section 45 as it then fell through to Section 24 of the BVI Act itself. That's what we're saying.
And so are Section 45 and Section 37 to be read literally?
No. I mean, my lord, my point would be that they are wide enough to include the freezing order jurisdiction, which is triggered in the manner in which one has seen that I've explained by reference to the focus on the enforceability of the possible judgment, as recognised by Lord Bingham. Indeed, as is uncontroversial, the description and definition of what the freezing order does. What isn't appropriate is to take a narrow reading of those statutes and then apply it to an injunction which simply couldn't exist and couldn't have been created if one did apply that reasoning at the time it was created. It's inconsistent. Now, how wide it goes, my lord, and it may very well be that the lesson to be learned, if I could respectfully put it, is that by adopting such a narrow constraint, which then needed to be and is constantly the subject of detailed scrutiny on a case-by-case basis in new circumstances that come about beyond the reach of the freezing order jurisdiction, that one should say that should be careful not to lay down any particular criteria for all forms of injunctions. And that's the problem, I think, that happened with North London Railway, that it laid down a criteria that may have been perfectly appropriate at the time for the old form of interlocutory injunctions, but plainly doesn't apply and couldn't apply to a freezing order. So, but my lords, the Lord Justice Bridge dissented in the Court of Appeal, and as I say, Lord Denning agreed with him. And can I just sort of, we make the point that he relies on the three cases and their factual scenario. But if we turn over to 12816, you can see that the two alternative ways in which the plaintiff's case is put. One is that the underlying claim for damages can come within, and the second one is that if you can't, the second one is that if for any reason the court cannot entertain a claim for damages, nevertheless the claim for an injunction effectively as a standalone follows. And he says, and they all say, and there's no real disagreement about the plain natural meaning of the words or the literal meaning of the words. He accepts that it's possible. It's difficult to see how one would argue against it. At G on 1286, this is the score draw point. he's not really getting very much out of Osler or Société Générale Dreyfus. But interestingly, my lords, at 12817, he says at A, if, however, the plaintiff's alternative claim, this is the standalone claim, to a limited jurisdiction has to be considered, the defendants rely upon a formidable body of authority to the effect that the court will not entertain a claim to an injunction, save as related to a legal right, which is itself justiciable and enforceable by the court, and that's North London Railway. So he's saying he actually favours, if he was pushed, the one that brings the underlying cause of action in. But he's saying that the North London Railway is a complete bar, and that line of authority is a complete bar to a standalone freezing order because it doesn't entertain a claim to an injunction relating to a legal right, which is itself justiciable and enforceable by the court. Well, it doesn't. That's absolutely true. It doesn't do that. It never has, and it never would. That's not what it does. But then he tells us that he can decide this on more broader considerations. And taking these briefly, the broader consideration that he first considers, my lord, at 12817, is effectively, well, the freezing order jurisdiction is a new creation and therefore can't fit within the existing gateway. It couldn't be expected that it was assumed it would go in that gateway. My lord, we would challenge that as an appropriate way to interpret the gateways and recommend the Jersey Royal Court's approach that one looks at the injunction gateway, like any gateway, in the light of what the current law is. So I think others more learned might talk about ambulatory aspect of gateways and judgments and statutes always speaking, as then Professor Burrows did in his Hamlin lectures that we cite for your lordship's reference 14228. But I wonder whether this argument in fact works in any event, because the decision in the Susquehanna was the first freezing order was around 1975, and the Susquehanna's considering the rules introduced in 1976, and so the rules had them. Not saying there were any changes in the rules. I haven't gone back to check all of that. I'm not making that point. But the rules were in fact changed after the freezing order had been recognised. And one might think that if the rules caused a difficulty, the plain and natural understanding of the meaning of the words used were causing a difficulty in the light of the freezing order, some change might very well have occurred. But we say that obviously thereafter, the rules have gone through numerous different editions, all in the light of the existence of the freezing order. And then there's a discussion about the exorbitant nature of service out. All I would say on this next section, Lord, is I don't believe that the answer to this appeal is going to lie in some erudite debate about Abella and Four Seasons and Browning, which I know your lordships have had many, many times on other related matters in the past. Whether one gives it a narrow or otherwise interpretation, presumption or no presumption, the plain natural meaning of the words speak for themselves, and we don't accept that that is going to help. But ultimately, one would approach it, we say, along the a Wrexham approach in the Court of Appeal, that maybe we just don't have presumptions and we just look at the words that we used. I mean, it's not a very radical proposal, and seems to be rather sensible as an attempt to square the arguments between Abella and insofar as there are differences, and Four Seasons and Brownlee. But ultimately, Lord Justice Bridges' conclusions and findings come down to spirit. And spirit plays a big role in injunction gateways arguments, and one almost is tempted to think of Star Wars and think of the Force as stronger than this one. But two strong pointers are identified by Lord Justice Bridge, but both of them are flawed, it seems, for the same reason. This is 12818, beginning at F. I mean, effectively, the point he makes is that why should a secured creditor be limited to recovering assets that are the subject of a security when an unsecured creditor can come along with this newfangled freezing order injunction and freeze all the assets and pursue the entirety of the debt claim? And on its face, one might say that does seem a little bit unfair. The problem with that is that Lord Justice Bridge is carrying forward the only version of the argument he thinks can work, and that is injunction with an underlying cause of action. That's not our case. Our case is standalone. And you don't, when you get a freezing order, assert a claim to anything. You don't get a debt recovery. There's no claim. Whereas in Gateway K, there is a claim. And therefore there is a marked difference. But it shows that the rejection of the argument was very much standalone rejected on North London Railway, the alternative rejected on Spirit, but a Spirit that couldn't apply to a standalone injunction argument. Lords, turning then, if I may, to the House of Lords, beginning at 12828 of the bundle, if I may. And one will see that in the reply at F to G, just so that we make the point, the argument that's being put forward by the appellants is, as Mr. Lloyd QC says, until this case, it had always been taken for granted that to obtain relief sought here, the underlying cause of action was within Order 11, Rule 1. So it's the underlying cause of action has to fall within the gateway. Then turning and it may just be worthwhile, Your Lordship's noting 12820 G to H. This is the argument that was put forward, and effectively what it says is that you can't have an injunction with an underlying cause of action that's outside of the gateway. That's clear. So the underlying cause of action goes away. You can't have an injunction without an underlying cause of action because of North London Railway effect. You can't have a standalone injunction. So that's how the argument is put. So it's worth seeing how that was put before Lord Diplock. Now, 12831, Lord Diplock expressly says that he's not engaging in the underlying nature and structure of the freezing order jurisdiction for the reasons there, and that he's answering this appeal, he says, on the grounds of Mr. Justice Carr and Lord Justice Ridge. So that's A to D. And then one can see at E, he says the subsection, speaking as it does of interlocutory orders, presupposes the existence of an action, actual or potential, claiming substantive relief, which the High Court has jurisdiction to grant, and to which interlocutory orders referred to are but ancillary. This factor has been present in all previous cases in which array of injunctions have been granted. And by reference to all, he means the three cases that have been granted. Now, as a consequence of not engaging in the underlying nature, as Lord Nichols says in Mercedes-Benz, Lord Diplock simply applied the ordinary interlocutory injunction criteria to the freezing order. That's the consequence of the refraining from grappling. There was no separate independent analysis of the freezing order jurisdiction. And just for your Lordship's note, that's Lord Nichols at 11761. And we say that effectively what happens then in the scheme, and your Lordship has already seen it in the run-up from Mr. Justice Carr and the Court of Appeal, is that there's a conflation of what we call the power issue and the territorial jurisdiction issue. such that the territorial jurisdiction issue is decided based on two arguments. Can't have an underlying cause of action for damages that don't otherwise fall within the gateway. Therefore, that first primary argument that's put is gone. Left them with an injunction on your own. You can't have that because there's no such thing in North London Railway. And realistically, Lord Diplock's reasoning is to be found at 12832 between D and F, when he tackles the question of the jurisdiction gateway for the underlying contract damages claim. And the last sentence is really all one needs to see, because there's no dispute it doesn't fall within the gateway. He says, so there is nothing here on which to found an action within the jurisdiction of the High Court to which a waiver injunction can be attached. So that's his position. And in many ways, what follows from his judgment is a countering of other arguments, but his real position is there's an absence of an underlying cause of action here, and therefore there's nothing to attach the injunction to, and that is prime North London Railway reasoning. Now he says, he looks at the injunction gateway and he examines the argument at the bottom of 12832, the last two sentences. The argument runs thus: in contrast to the other rules, power to permit service out of the jurisdiction under sub-rule I, the injunction gateway, does not depend upon the nature of the plaintiff's cause of action against a foreign defendant. It depends entirely upon whether the facts on which the action is founded would support an application for an injunction ordering the defendant to do or refrain from doing something within the jurisdiction. Injunction here includes an interlocutory injunction, so where, if the action were allowed to proceed, the facts on which it is founded would support an application for an interlocutory injunction, there is no need for them also to be capable of supporting a claim to judgment, the final injunction, as distinct from the claim for damages for whatever cause of action may be constituted by those facts. And he says that found favour with Lord Stenning and Lord Justice Lawton, but he sides with Lord Justice Bridge and Carr. But one might ask, what is wrong with looking at the injunction gateway and determining whether or not the facts justify the granting of injunctive relief? The reason Lord Diplock can't accept that as a proper approach is because of his understanding that the interlocutory injunction must bring with it an underlying cause of action which is justiciable in English law. And he goes on to say that he accepts that the terms are terms of legal art, with respect to whatever that is intended to mean. And he says the sub-rule speaks of the action in which a particular kind of relief, an injunction, is sought. And this presupposes the existence of a cause of action on which to found the action. A right to obtain an interlocutory injunction is not a cause of action. It cannot stand on its own. It is dependent upon there being a pre-existing cause of action against the defendant arising out of an invasion, actual or threatened by him, of a legal or equitable right to the plaintiff, for the enforcement of which the defendant is amenable to the jurisdiction of the court. The right to obtain an interlocutory injunction is merely ancillary and incidental to the pre-existing cause of action. It's granted to preserve the status quo, pending the ascertainment by the court of the rights of the parties and the grant to the plaintiff of the relief to which his cause of action entitles him, which may or may not include a final injunction. And then we see in the next paragraph that the High Court has no power to grant an interlocutory injunction except in protection or assertion of some legal or equitable right which it has jurisdiction to enforce by final judgment, was first laid down in the classic judgment of Lord Justice Cotton and North London Railway. And that is obviously the key analysis. But when one looks at the reasoning between C and F, it's plain that it does not apply to a freezing order and could not apply to a freezing order when properly analysed. It is the North London Railway reasoning. There is no, we put aside obvious matters such as preserving the status quo and all of that. But it's dependent upon a pre-existing cause of action against the defending arising out of an evasion, actual or threatened by him, of a legal or equitable right. And it's all about the entitlement to the injunctive relief being inextricably intertwined with those underlying rights and being justified by reference to those rights. And that is not what, in my respectful submission, a freezing order is all about, for the reasons that I've already spelled out. It doesn't protect and it doesn't preserve the rights that are in dispute. It might be said, I guess, well, it does if one takes a sort of level of abstraction so high that we're struggling for oxygen. You know, that you say, well, it does because it's helping the enforcement process, which then helps the other process, which then helps the. Let's not kid ourselves that is what's going on here. The freezing order is looking, as Lord Nichols tells us, in the different direction to the interlocutory. The interlocutory looks back at what is going on in the action, and is it fashioned to assist that process, whereas the freezing order is looking forward to where might the consequences of this action end up, and that is in the enforcement process. Might that be the BVI? If it is, and you can persuade a BVI court that it is on the radar, then it's appropriate that it ought to go there. But the assumption flowing through all of this, from Mr. Justice Carr, Lord Justice Bridge in dissent, and Lord Diplock, is that connection that just doesn't exist. And looking back at my statement of case, I feel a little bit guilty that I may have been a bit harsh on Lord Diplock in criticising him for failing to notice this, as opposed to it being an understandable consequence of perhaps the manner in which the case was presented to him, and that how the options, an injunction with an underlying cause of action, an injunction without, then the stark choices and the answers to those two propositions would appear clear to him based upon North London Railway reasoning and the acceptance that you can't get a cause of action before the English court unless it falls within one of the gateways. So it's understandable. And of course, at the very beginning, there's no doubt that Lord Denning was scrabbling about to try and find justifications for the freezing order that might pass muster. But we know from our own reading of it and from understanding the injunction that they don't nowadays pass muster, and Lord Mustell tells us. And so my lords, there are other parts of what's said here that I've addressed in the statement of case, such as the difficulties in seeing where Lord Diplock got pre-existing cause of action from. It's difficult to see because it doesn't appear to be in North London Railway, or as an essential part of North London Railway, unless one is saying that the rights that are in dispute, that cause of action had to have already arisen in order for the interlocutory injunction to give. But whatever the position is there, plainly for a freezing order, there may be circumstances where it needs to be deployed for the very same reasons prior to cause of action having formally accrued, whatever in fact that means. And what I mean by that last statement is that there can be various meanings ascribed to what cause of action means. But what I say here is that if you are able to persuade the BVI court or any court that there is a good cause of action which may very well accrue, leading to a judgment going to your judgment, your regime, your enforcement regime, then in principle, if you're able to persuade the court that there's a reason why assets may be at risk, then, and you provide, as is required, the usual cost undertaking and damages, and it may be a court would require a very high quantification of that cost undertaking and damages. There's no reason in principle, we say, for the freezing order to be limited to such a circumstance. And indeed, as has been pointed out by Lord Nichols in Mercedes-Benz, there's an element of circularity in the whole argument of tying it to a cause of action. Because as SPRI tells us, and common sense as well, that when one can say a cause of action is established when equity considers there is a need for an injunction, and where circumstances develop for the need for an injunction, then one has an established practice for the injunction, such as the freezing order now, to arise on the basis of threatened dissipation of assets, that somebody on the wrong end of that might very well not inappropriately say that they have a right to apply for a freezing order in circumstances where relief is given. But in this particular case, there is an underlying cause of action in Hong Kong, and it is being pursued. But I make these points just because I know your lordships will probably be considering the issue slightly wider as a point of principle rather than just simply in this case. One then also has other matters such as which we've dealt with in our statement of case, such as the Chabra jurisdiction, which, whilst often said to be supported and justified by reference to the underlying cause of action against the main defendant, the reality is that there is a separate injunction against the non-cause of action defendant, and yet there is no, as the name implies, cause of action against that defendant. We rightfully don't see that as being some bar in principle to the granting of relief. And my lord, as regards difficulties generally caused by the connection with the cause of action, you'll see in our statement of case that we've delved into areas that I normally wouldn't go anywhere near, tax cases and what have you, where dancing on a pinhead with respect as to whether or not a debt that's not yet payable is one that's sufficiently a cause of action and a pre-existing cause of action for the purposes of protection of assets by way of a freezing order. Inevitably, as one would expect, the learned judges dealing with these cases get to the right result. But my goodness, it can be sometimes a very difficult process of reasoning around and over and between the requirements laid down in the Susquehanna in order to get there. I mean, if one looks at a decision without going to my Lord Briggs sitting at first instance in Eggleton, one can see there that the party that obtained the freezing order, the creditor petitioner, had no cause of action against the third parties that may or may not have owed the company money, which would be pursued not by the petitioner, but by the divisional liquidator once appointed. Now, was it sensible to grant the freezing order with respect to Woodbridge? Yes, it was, because a cogent case could be made that the assets were at risk. But one has to spend a long time trying to justify it by reference to criteria that, in fact, has no application to the freezing order at all. So, moving on, if I may, my lords, it said against me that, well, you're attacking North London Railway, but just look, 7 House of Lords cases have applied North London Railway post Susquehanna and before Mercedes-Benz. Lord, I haven't got time to go through them, but 3 of them, Gourrier, the question there was the absence of jurisdiction to bring a relator action against the post office without the Attorney General's consent. I'm not saying that North London Railway is not prepared to hear a tip to that or to move on. They're not. In none of these cases is it the subject of any detailed scrutiny or challenge. Richards and Richards, it's an injunction to oust a husband from the family home on a divorce. As I read it, the power to grant that injunction did or didn't arise under Section 1 of the Matrimonial Homes Act 1967. So far different considerations. And in Bremer Vulcan, it appeared that the decision was based upon a plague on both houses. You both had a duty to keep the arbitration moving, and you didn't, so one can't now blame the other if you didn't do that. But when you then look at some of the other cases, your South Carolinas, your British Airways and Lake, and we've been through them in our statement of case, the one thing that comes out, and what they do reveal, is a general unease with a strict, rigid categorisation of Lord Diplock in the Susquehanna. Indeed, he himself said, in the context of anti-suit injunctions, that he was perhaps too narrow. But of course, once one accepts that out of Section 45 or Section 37 can flow all manner of different types of injunctions, it only goes to support my proposition and submission that you shouldn't be putting this type of injunction back into an inappropriate box, the American cyanamide box. I mean, when I was speaking of whether to say this, but I am going to say it, and that is, I mean, if I appeared before you as a wet behind the ears junior barrister seeking a worldwide freezing order with a skeleton that only referred to the American cyanamide, you very politely but very firmly tell me to go back and have a little rethink. So why, when as a matter of practice, there's no debate, it's not controversial, the two animals are different, do we constrain the development of one by reference to criteria that was developed solely in relation to the other? That's what we say. But when you look at those other cases, you've seen them, so I don't need to take through them. And there's a masterly analysis in from Lord Scott, if I might say, in Furry and LaRue. The one point that's missing from his run of cases is he does not talk about a point that I think is important, and that is Lord Brandon's recognition that the Moravian or freezing order fell within the special exception to the two category requirements that he was putting forward. I'm at a loss. I really am at a loss as to how these points have gone unnoticed or unpursued in subsequent litigation. Here, Lord Brandon, given the leading judgment, says that the freezing order, albeit it was not dealing with a freezing order, but he says the freezing order falls within the special exception. And that is at 12942 H to the following page. And 40, 12942 to the following page. He looks at the two categories and then refers to the freezing order being in the special exception category. That was also a view expressed by Lord Mustel in Mercedes-Benz. We get that at 11755. So just pausing there, we have a situation in which in these cases that flow in immediate aftermath of the Susquehanna, we have a general unease with the rigid characterization, but a potential excising of the freezing order as a special exception to Lord Diplock's categorization based upon the need to aid a legal right. And what I said to you earlier on, that I'm seeking to try and persuade your lordships to see the consequences of many well-established, already established principles, the significance of which may not have already been seen. Here, it's been excised, or the suggestion is it should be excised, or has been excised. It's no answer, as my friends for Broad Idea suggest in their statement of case, that this is now a moot point because of Section 37(3) of the Supreme Court Act, because the board has already made clear that the freezing order was doing all of that it's allowed to do under Section 37(3) before the Act, and therefore it was applicable in Bermuda, and that's in Walsh and Deloitte and Touche at page 13234. So we say that it's not right to say that the people haven't noticed the difference. It's not right to say that people haven't even extracted it from the categories. But what hasn't happened, other than Lord Nichols in Mercedes-Benz, is a detailed grappling of it, and what does it mean, and how is it impacted by the North London reasoning. Lord, and I'll leave my statement of case to talk about the impact of those other decisions, which your lordships will see between the Susquehanna and Mercedes-Benz. And then in Mercedes-Benz, if I could very sort of briefly run through I hope it's useful, Lord Nicholas's reasoning in some, I have it at 10 steps. And I'll just give you the page reference to support the proposition without taking your lordships to it. But the step one is he recognises it's a good thing to do. That's 11759. Just pausing there, I'm criticised for bringing an appeal based simply on policy and not analytical rigour and principle. But the policy tells us where it's a good place to go. Legal principle and best traditions of the common law gives us the vehicle to get there, if appropriate. And we say that it's clearly a good place to go, the ability to have a standalone freezing order and the ability to serve it out. And we say that there is legal principle and development of the common law route to getting there, but that it is not without serious analytical rigour, as I hope I've shown in terms of going through the cases to date. Step two, the fact that the freezing order is often granted in the same proceedings as the substantive dispute should not obscure the fundamental difference between the two, the latter being unconnected to the rights in dispute. And that's 11760, 11761. And that's, of course, a point that that's 11760 C to G and 11761 C to E. And that, of course, my lords, is the starting position of Mr. Justice Carl, or Justice Bridge, and Lord Dicklon in their various judgments. Step three, if the court is prepared to grant the freezing order in aid of enforcement of a domestic judgment, that's a strong case to do likewise for a foreign enforceable judgment. Why? Because the process that it's seeking to protect is the same, the enforcement of a judgment. And you've already decided as a jurisdiction that that is a judgment that is sensible of enforcement. And that's 11761 H, 11761 2 C. Step four, the Susquehanna was analysed solely from the perspective of the traditional interlocutory injunction, and that is 11761 H, 11762 H, the following page. Step five, subsequent cases such as South Carolina, etc., support a less rigid, modified approach to the interim relief. He accepts that they don't identify a rationale for the freezing order, and I accept that, but I've not sought to gain a rationale for the freezing order out of that run of cases between the Susquehanna and Mercedes-Benz, save to note that they did not think the rationale and criteria of North London Railway plainly applied, given the suggestion that it's in a separate category. But what it does show, he says, is that there's no need to squeeze the freezing order into the traditional approach, and that's 11763 C to G. Step six, he notes that Lord Brandon, and I would add Lord Musto in the Mercedes-Benz, placed the freezing order into a special exception category, not subject to the traditional constraints. So he's not going off with respect on a frolic of his own in reaching the conclusions and his reasoning. He's carefully noted what I've shown you, lordships, and that's 11762 H. And step seven, he recognises that in the context of the traditional interlocutory injunction, the Channel Tunnel itself has developed the law such that one doesn't now need the underlying cause of action to be in the same jurisdiction as the interim relief. And he says that's 11762 H, 11763 H. And he says that if it's okay for the interlocutory injunction, which on the arguments I've been putting forward, has a greater connection to the underlying rights, for the reason everybody said, a fortiori, he says, for the freezing order. Step eight is the power to grant, should recognise the power to grant the standalone freezing order at 11764 A to B. And step nine, dealing with the supposed need for an underlying cause of action, he makes the point that I've already addressed you on about circular meaning, and 2, talks about the freezing order protecting a prospective right of enforcement, and that it is the only relief sought in the claim, and so no bar. In other words, what he's saying is you're not getting the underlying cause of action, substantive cause of action being brought in. It's the only relief that's being sought. If you say, well, you can't have an originating process unless you're resolving disputed substantive rights, he refers to examples such as Norwich Pharmacal, which is relief available to determine what your legal rights are and what steps you might need to take for your legal rights, and isn't, in fact, dependent simply on showing that you might have a good cause of action. And then step 10, he challenges the appropriateness of the requirement of a pre-existing cause of action on the lines that I've indicated, but says that it's a short step from that to apply the same approach of recognising the anticipatory nature of a normal injunction. It's a short step from that to say that one should recognise an injunction made of a prospective right of enforcement. And I would just say, my lords, we've set out in our statement of case trying to analyse the underlying nature of the freezing order in terms of an existing right, procedural right, to when one is about to engage in civil process, that the end game isn't taken away, that the person that's engaging in that process will be a person that will be held to play by the rules. Those rules apply to the enforcement stage just as much as they apply to the individual stage. Now, that's a procedural right. It's not a substantive right, so it doesn't get us necessarily into North London Railway. But I mention it because whilst we don't disavow Lord Nichols's characterisation of it being a prospective right of enforcement for which one gets an injunction, what we would say is that one can also say that as I stand here making the application for a freezing order injunction, I have a right to that freezing order injunction, and therefore we say that there's more than one way to justify why equity intervenes in the case of a freezing order.
Yes, Lord Legger.
I do apologise, my lord.
Mr. McGrath, I may have missed it because your case was extremely long, but do you rely somewhere in it on the fact that the High Court of Australia has approved Lord Nicholls' reasoning and analysis of the freezing order, the basis on which it's the conceptual basis for it?
My lord,
resources.
My lord, I tread carefully when one deals with the Australian authorities on the issue, because it will be said against me that they expressly chose a different statutory underpinning to the freezing order, which gave them a much wider ground upon which to justify. And what I've done in the statement of case, my lord, is that I've said, well, you can characterise this as a procedural right. And then on the other hand, there are these Australian cases which talk about protecting the process. And looking at cases such as Cardeal, one talks about administration of justice and frustration of the process. And indeed, I think Lord Bingham used the language of protecting the process. But the problem with that as a justification for the freezing order jurisdiction on its own is that it doesn't bear the reality of the fact that the court doesn't grant a freezing order of its own motion. It grants it on an application of one party who's prepared to give a cross-undertaking in damages to protect the position of the defendant, possibly fortify, and subject to all sorts of criteria. So we say it's an amalgamation of the two, so that one is not, because what we do say in the statement of case is that there were those who criticised the Australian approach as being too wide and not being as being almost an unfettered right. Now, I don't think that's right, because ultimately one comes down to self-contained freezing order jurisdiction regime, which is heavily regulated and controlled. But I think it's right also to assess the Australian by reference to the interest of the party seeking to apply for that relief, and that interest is what I try to describe as a procedural right, and Lord Nichols describes as a prospective right to enforcement. The end game is that you're protecting the integrity of the enforcement process, and clearly, insofar as Australia emphasises that aspect, then we would agree with it, with those caveats. My Lord, I'm conscious it's 1 o'clock.
Very well. We'll adjourn then and sit again at 2 o'clock.